Here, Your Honor, it is undisputed that the TikTok platform is downloaded for free. There is no exchange of money. And if there's no exchange of money, there's no sale, there is no lease.
Okay, pages 9 and 10 is our 9:30 matter. Our 9:30 matter is case 886-127, State of Nevada versus TikTok. Councils, feel free to come forward, and then I'd like you to make your appearances when you have a moment, please. Yeah, appearances, please.
Good morning, Your Honor. Vandal Jones on behalf of the state of Nevada.
Good morning, Your Honor. Michael Gain on behalf of the state of Nevada as well, and I'll just announce the folks appearing, just observing only on Zoom on behalf of the state of Nevada. Looks like we have Ryan Moore, Michaela Holweiler, Matt Bush, Brian McMath, Sydney Jing, Laura Rios, Samantha Feely, Anthony Walsh, Michael Gorwitz, Naomi St. Sume, and Katrina Stark. And I believe I got everybody.
Okay,
Your Honor, David Slade for the state of Nevada.
second table.
Mark Kruger on the state.
I'm sorry.
I can't hear anybody.
Yeah, you all are, because there's a lot of rustling of papers and kind of quiet voices. Feel free. A nice voice, we can hear you, please.
I'll project, Your Honor. Good morning, David Slade for the state of Nevada.
Ooh,
Nirvana.
mispronouncing our state's name 1 month before Nevada Day? Ooh,
We're still working on it, Your Honor.
you do not have a jury, yeah, juries don't like that. Sorry, counsel, the court takes no opinion on it. Go ahead, counsel.
Mark Kruger on behalf of the state of Nevada.
Raquel Fulgham on behalf of the state.
Phil Carlson on behalf of the state of Nevada.
Counsel for Jones, where are
Good
you?
morning, Your Honor. Colby Williams, Campbell and Williams on behalf of the defendants, and let me just take the lead here and introduce Blaine Evanson and Sean Mather, both from Gibson Dunn, both who have been admitted pro hoc vice, Your Honor.
Anybody remotely that you need to
Not
introduce?
appearing that I need to address, or
Okay.
excuse me, introduce.
Thank you, welcome everyone. So first, just let's get through the procedural aspect. The court had signed the pro hocs. I've been in trial with the other things. I assume you got your NEOs in, is that correct?
We did, and we've done the notices of compliance as well, Your Honor.
Perfect, thank you so much. Okay, and on your side, you got yours taken care of,
My understanding that they've all been signed and filed with the court.
we didn't see there was anything outstanding from anyone, so, okay. So let's get to substance. So feel free to sit down, stand up. Are we having one person on each side taking the weathering oar on? How are we
Sorry to
doing?
interrupt. I was gonna make a couple of comments and suggestions, of course, subject to the court's discretion, and I think Mr. Jones has a couple comments as well. What we had,
You all resolved everything?
well, I think there might be a difference of opinion, Your Honor.
Sorry,
But,
go ahead, please.
what we had thought would be efficient was to group the issues into basically three segments. First would be to address personal jurisdiction. We would argue, the state would argue, we would do a reply and close that issue off. Only because there are so many issues that by the time you hear about personal jurisdiction again, if we go straight through, it may be over an hour. But give or take, that would be segment one. Segment two would be the CDA section 230 argument grouped with the First Amendment argument because they're very closely related. And then group three would be the state law arguments under the 12b5 motion as to why the claims fail in our opinion. In conjunction with that, Your Honor, we had planned to argue that between Mr. Evanson and myself, with Mr. Evanson handling the first three issues, and then I would handle the state law issues, which would be the third segment if the court proceeded in that way. Even if we went straight through, we still propose to divide the arguments that way with respect to those issues.
Any objection from your end?
Yes, Your Honor.
Okay, because as you, just the FYI, for those of you who might be newer to the court, right, is the court's fine if multiple parties argue, if all parties are fine with it. If there's objection, I have to hear it because of the way these pleadings were done as a solid pleading, right? Not separate motions, but let me hear counsel for plaintiff, because are you wanting multiple riders on those horses too?
You actually made my point. I'm going to be the only person arguing on behalf of the state. This was filed as one motion. I did discuss with Mr. Williams, who I've known for many years, and I explained to him this is certainly nothing personal. It's just I feel that would be inappropriate under the circumstances to allow them as essentially, and I understand their position probably is they're not tag teaming me. But from my perspective, that's in essence what it would amount to. And I think that since they filed it as one motion, then it's one motion and one party gets to argue, or one person gets to argue on behalf of that party. So that's my first concern. I understand you have wide discretion to do what you think is appropriate, but that I think would be inappropriate. And based on the custom and practice, as I understand it, in the 8th Judicial District Court. The second issue it relates to the order of the arguments or the method of arguing. So having one argument first and then another, that makes a lot of sense in one respect, that it gives the court an opportunity to focus on one particular issue, have the full argument made and then make a ruling or defer as the court sees fit. The concern I have is this, and this is what I expressed to Mr. Williams when he brought this up to me, because of the fact that these are some pithy briefs here. They have, well, I guess the court will determine how pithy they are, but they're certainly thick. There's a lot of stuff here. And my concern is even though the court has given us a significant period of time to argue these things, the court has its limits to time. And so what I'm concerned with is there may be, allow me, if you will, a limited amount of time to argue the last arguments that are going to be made. So I don't want to put myself in a position where I don't get to argue my points fully because of the length of time that is taken on the first issue or the second issue by the time we get to what they referred to as the third issue. So that's my concern, and I obviously will defer to the court however you want to do it. But I have at least, and we won't know if that concern is a legitimate concern until the arguments are over. In which case I may have been prejudiced, and so I'm just trying to avoid any potential prejudice to the state by having that process be the manner in which we proceed today.
Okay, let me tell you what I'm thinking.
Okay.
The arguments need to proceed all together. Motion dismiss, that's the proper way because we run too many different issues and with regards to if people want to do it and then people say that they may not have enough time. We were very clear. You got your hour, right? Each side, you can appreciate you probably heard. I'm in the midst of a trial and I got jurors driving in from all over the county and I've got to be fair to them and fair to you. We offered you to change you to a different date. We understood you all didn't want to, so. Right, everyone got the message, yes?
We did, Your Honor.
Okay,
We spoke with
okay.
your staff.
I'm just saying, we offered to switch you to a different date where we'd had some more time. Trials are trials, you all know that, they need to take priority, particularly when it's supposed to be jury deliberation and closing argument day. So I think the smoother way to do that, the more fair and accurate way is that these were filed as one motion is to address them all. I am more than cognizant that there's a multiple issues that you've all appeared before this, well, most everyone's appeared before this court before. That's not unusual. Get it a lot. So that's not an issue. The two attorneys arguing, I am inclined to allow two attorneys to argue. And the same thing with regards to on plaintiff's side. If there's somebody who wants to bring in something that you are able to do. The reason why the court's inclined to do that is I do have to take into account the issue of people wanting their attorney of choice, and that as you all both have presented, right, a plethora of things from other jurisdictions, right, including quote of how other courts that have ruled throughout the country on similar motions, that realistically don't have an issue of not having the counsel of choice, being able to argue it and have that cloud the actual substantive rulings. Okay, don't hold that to be on other smaller issues or in the midst of trial right in front of a jury. Wholly different situation, but I think that is the appropriate thing because based on the pleadings as presented to this court, you all have referenced things outside and people may have already prepared that way for this issue. So I think that's the fair way to go there and not multiply the issues. So that means you're going to get it, but that doesn't mean you get another minute. So if one person's going to be loquacious, then you're going to have less time, right?
We understand, Your Honor, and we appreciate the court's ruling.
Okay. Are you ready to go into substance now? Does
No,
any, sorry, go ahead, Mr. Jones, go ahead.
The state is ready. Proceed.
Okay. So, was there any issue about, because you all had a lot of stipulations on this. When we did the math on defendant's reply, is there any issue about it being timely or not timely? Because there's two ways we calculated it, but it looked like you all had an agreement that it was the date, right? That's not an issue, is it?
I'm not aware of that being an issue, Your Honor.
More am I, Your Honor.
Okay. Add that as a question mark. Okay, so let's start with your walking through. 9:43, whoever's going first, go ahead, please.
Thank you, Your Honor, and may it please the court. First of all, let me thank you for granting my product Vice admission. It's an honor to be in your courtroom. And there's obviously lots to cover today, and we are well aware of the court's other constraints, and so I'll try to be brief. I'm going to start with personal jurisdiction, and then as Mr. Williams mentioned, I'll cover the Section 230 arguments and the First Amendment. The state's complaint really has two parts to it. The vast majority of the complaint describes the features of the platform that they are challenging and the statements that they challenge as false or misleading. This section of the complaint is not, has nothing to do with Nevada. It's not directed at Nevada. The features, there's no allegation that the features were created for, or directed to Nevada. That portion of the complaint could be pleaded the exact same way by any plaintiff anywhere in the country. Then there's a smaller section of the complaint, paragraphs 82 to 86, where the state alleges a few contacts with Nevada. They talk about contracts with Nevada residents. They talk about a PTA president from Nevada joining a national Zoom call. They talk about TikTok participating in the Consumer Electronics Show. The evidence.
Getting some video billboards that they showed up.
Billboards, exactly. That's in that section of the complaint.
Okay.
The evidence that they submitted on many of those allegations is very flimsy. As to the what they call the Nevada PTA program, what that was is, it's clear from pages 239 to 240 of the appendix. That was a national Zoom call with 91 participants, where there was one person from Nevada on that call. And where they say that TikTok maintains a presence at the CES conference, they submitted web search results from a Google search where they searched for TikTok and CES. Now, I can't even read the results, but they certainly don't show that TikTok had some overwhelming presence at the Consumer Electronics Show. But those sort of problems with their evidence aside, the main problem, more important problem, is that this jurisdictional section of the complaint is the only place where these facts are alleged. They are not mentioned once elsewhere in the complaint, and they have nothing to do with the actual claims that the state is pursuing here. Same thing in their opposition. They have this nice little jurisdiction section of their opposition where they talk about all these contacts alleged to TikTok to have with the state, but then they do nothing with them elsewhere in their complaint. And the reason for that is that these claims that the state is asserting have nothing to do with the contacts that they are trying to use as a jurisdictional hook. And that highlights the two-part problem with their jurisdictional argument. The one, that what they're actually challenging, the actual substance of their claims, is not conduct directed at Nevada, conduct that occurred in Nevada, that is, engineered for Nevada, and it cannot give rise to personal jurisdiction. And the unrelated Nevada contacts that they allege in the jurisdiction of their complaint can't provide a jurisdictional hook because the state's claims do not arise out of those contacts. And the state does not cite any appellate authority at all supporting personal jurisdiction over an internet platform that operates, supporting specific personal jurisdiction over an internet platform that operates the same way in every state in the country. And if the state is right, and that simply operating a nationwide platform means that you are subject to personal jurisdiction in all 50 states, then the state has totally gotten rid of the due process defense of specific personal jurisdiction. They have completely collapsed general and specific personal jurisdiction. And that is exactly what the Supreme Court in Bristol-Myers Squibb said that you cannot do. In that case, the Supreme Court said you cannot simply allege enough contacts that at some point there are enough contacts with the state when aggregated give rise to specific jurisdiction. You're either at home in the state or you are not, and there's no claim whatsoever that TikTok is at home in Nevada for purposes of general personal jurisdiction, or the claim has to arise out of or relate to the contact. And so this disconnect in the state's complaint between the facts that they allege for jurisdiction and the claims they assert is fatal to personal jurisdiction in this case. And the state's attempt to subject TikTok to personal jurisdiction is particularly pernicious when viewed in the broader context of what's going on here. TikTok is subject to general personal jurisdiction in California, and there are dozens of cases that have been filed there, and TikTok is defending them. But on the features that the state challenges in this case, the plaintiffs have lost. The federal district court in the MDL in Northern California ruled that those features are either or the claims related to those features are barred by either section 230 of the Communications Decency Act or the First Amendment. But if the state is right, then TikTok has to continue defending those same claims in all 50 states where it's going to get conflicting rulings and duplicate efforts. And that's already happening. And that is simply completely anathema to the due process concerns that animate the personal jurisdiction doctrine. And there are a host of federal appellate decisions that have grappled with this question of personal jurisdiction for interactive online platforms that are available throughout the country. And we pointed the court to the AMA decision out of the Ninth Circuit, the X-Mission decision out of the 10th Circuit, and the Johnson versus Huffington Post case out of the 5th Circuit. These are nationally available platforms. They provide an interactive experience in one way or another. They target individuals throughout the country. But because the platforms operate the same way in all 50 states and do not target any individual state, they can only be sued in the jurisdiction where they are at home, where they're subject to general personal jurisdiction, unless a claim actually arises out of a contact that that the platform has with a particular forum. And the X-Mission case describes this in detail. It says there has to be a particular focus by the defendant on the forum state for specific personal jurisdiction to be appropriate. The conduct must be expressly aimed at the forum state, and the platform's availability in the forum is insufficient. And these courts have all explained, as I'm arguing this morning, that if it were otherwise, then the due process defense of specific personal jurisdiction would no longer exist for internet platforms. They would essentially be subject to general personal jurisdiction in all 50 states. And the Supreme Court has expressly rejected that. Now, the state's lead case, the one that they lead with in their jurisdiction section, is a case from the Supreme Court called South Dakota versus Wayfair. That case is not a personal jurisdiction case. It does not even use the term personal jurisdiction in the opinion. It is a Commerce Clause case about the scope of a state's power to tax. It has nothing to do with personal jurisdiction. The state also relies on the Ford case from the Supreme Court. But Ford had in-state brick and mortar car dealerships, and the in-state advertising was used to direct people to the car dealerships. And the court said in footnote 4 of that opinion that it was not ruling and that the situation would be different if we were talking about an internet platform and e-commerce. So that case does not apply here. There are a series of cases dealing with this question of interactive online platforms, and the state simply ignores those cases. Again, the AMA case, X-Mission case, and the Huffington Post case. They cite the Arkansas Superior Court trial court decision. That case has been taken up by the Arkansas Supreme Court on a writ. And so that case is, no longer something that should be relied on. It's going to be reviewed by the highest court. But the federal appellate authority on this question is uniform and requires the court to deny personal jurisdiction in this case. Happy to take any questions that the court has on personal jurisdiction. But if not, I'll move on to section 230.
Do have a quick question. So what are you contending would be the remedy for the state of Nevada if it had any concerns about your client? Are you saying they'd have to go to California and address those concerns? Because, you know what I mean?
Yes.
You're not the first. You probably have done your research on me, so you know you're not my only case kind of in this area that's before this court. But so I asked the same question last time, I'm just saying, so if you all check transcripts, you would have seen I asked the same question last time, because that is an issue. I mean, where would the state of Nevada be able to get some kind of remedy if they're asserting that they are aggrieved here in the state of Nevada?
Yes, Your Honor, they would file suit in California, like many people have. Plenty of out-of-state people.
States, are you telling me the state of Nevada would have to file in California to to protect rights of its Nevada citizens. Are you saying that any other state has done so?
Yes, Your Honor. That is exactly right.
Okay.
Because the test here, and the law is absolutely clear on this, I point the court to the Walden case from the Supreme Court. The law is absolutely clear that the personal jurisdiction analysis is not focused on the harm to the plaintiff. It is focused on the defendant's contacts with the forum.
Right.
And so it does not matter that we're dealing with the state of Nevada here. It does not matter that the state of Nevada is purporting to assert the interests of Nevadans. What matters is whether TikTok has availed itself of the forum. And so I understand the sort of the concern for the court, but it is not legally relevant that it is the state of Nevada asserting the interest here, because this is a due process rule under the federal due process law.
The court wasn't asking the question and flipping the law.
Sorry,
The court it was more like kind of the reality. Are you saying that any states have asserted their rights in California?
Yes, Your Honor. And I don't have the list of which states with me, but I will give that to you on rebuttal. But yes, and plenty of out-of-state plaintiffs as well. Those are being litigated in the MDL in Northern California.
Okay, thank you. That was my only question. Go ahead, please. Next topic. Were you doing 230 or what are you doing?
I'm doing 230, yes.
Okay.
So section 230 shields online platforms from liability for publishing third-party speech. And the statute says that no provider or user of an interactive computer service shall be treated as the publisher. That's the operative language. Shall be treated as the publisher or speaker of any information provided by another information content provider. And courts have consistently interpreted section 230 broadly. They have said that close cases must be resolved in favor of immunity. And the reason is these courts are trying to, they're acknowledging that Congress passed section 230 to promote the free exchange of information and ideas over the internet, and to encourage voluntary monitoring for offensive or obscene material. So courts in a litany of cases discussed in our papers have interpreted section 230 to immunize not just the simple publishing of the third party's text on the platform, but for the features and conduct attendant to that publication. And they look to just the common sense definition of what constitutes publishing, that it's editorial decisions and functions ancillary to the decision to publish the content. So they have held that reviewing, editing, and deciding whether to publish third-party content, that's publishing activity, that deciding whether to withdraw, postpone, or alter content, recommending user-generated content, and sending notifications about that content. These are all functions that are attendant part of the publication of third-party content, and they are covered by section 230. And in the MDL that I mentioned, a decision last year against TikTok, challenging the very features that the state is challenging in this case, the court ruled that these same features are included within section 230 because they are attendant to the publishing process. Now, the state argues that its claims are not barred by section 230 because it has pleaded its complaint to target TikTok's features rather than the third-party content that the platform publishes. But section 230 does not say that a platform is immune only for third-party content. It says that you can't treat the platform as a publisher of third-party content. That's what the plain text of the statute says, and that's the way courts have interpreted it. So the state is simply dead wrong as a matter of law in its argument that features are for some reason exempted from the scope of section 230. And we have a whole list, 10 bullets on page 12 of our reply brief, detailing all the ways in which courts have found that features of platforms that publish third-party content are included within the scope of section 230 and therefore cannot be the substance of a claim. The state harps on the Lemon case, but the reason section 230 did not apply there was that it was the platform's content and not the third party's content. And the court said expressly in footnote 4 of the decision that if the feature on Snap would have been used as part of a publication of third-party content, that it would have been brought within the scope of section 230. So the question is not whether the state has artfully pleaded its complaint to attack a feature rather than a particular piece of third-party content. The question is whether the claim in substance treats the online publisher treats the online platform as a publisher of third-party content. And there's no question that the same claims here do that the state is attempting to affect the way that TikTok publishes content. And if you look at each of the design features that the state challenges, they are all central to the way that TikTok publishes content. And so starting with the recommendation algorithm, this is from the way that the state pleads its complaint, the way that it is described the platform in the allegation. The state's claim is that the algorithm works too well, that it delivers content to users that the users find especially attractive, and as a result, they consume too much content. That's the substance of the state's claim as to the recommendation algorithm. But that claim treats TikTok as the publisher of third-party content. Publication almost always includes making choices about what to include and what to exclude. And that's what the algorithm does here. That's what they are challenging. Algorithms make recommendations based on the user's activity, and they decide what to publish. And the algorithm is therefore central to that publication process. Many courts have considered this same claim challenges to algorithms, and the courts have held that challenge to the recommendation algorithm treats the platform as a publisher and is therefore barred by Section 230. And I point the court to the Dyroff case from the Ninth Circuit, page 1098 of the opinion, and to the MDL, which again considered this exact same claim, exact same feature against TikTok. And the court held that whether, this is straight out of the opinion, page 833 to 834, whether done by an algorithm or editor, the decisions whether, when, and to whom to publish third-party content are traditional editorial functions that are essential to publishing. And the court dismissed that claim on the pleadings under Section 230. Second feature they challenge is endless scroll, what they call endless scroll in autoplay. That as you swipe up on the platform, that the For You page continuously gives you videos, and that those videos start automatically. Now, to clarify, that does not mean that you just open the app and it just feeds you videos forever. You have to swipe up and it responds to that input. But the state's claim is essentially that this feature results in the TikTok platform publishing too much content to users. But that claim treats TikTok as the publisher of third-party content. The question of how much content to deliver is fundamentally a publishing decision, a newspaper's decision of how many pages to include in a particular section is a publishing decision. And the courts that have considered this claim have held that the claim challenging what the state calls infinite scroll is a challenge to, or treats the TikTok platform as a publisher of third-party content. And I point the court to the Force versus Facebook case, and again, the MDL, which dealt with this exact same claim against TikTok. Now, I'm happy to keep running through all the features that they challenge, but the story is basically the same, that in each one of these instances, they are complaining about a feature on the platform, not in the abstract, but it's a feature that publishes third-party content. And in doing so, they are treating TikTok, the TikTok platform, as a publisher of third-party content, and that is exactly what Section 230 prohibits. Now, the state says at one point in its brief that it's not trying to stop TikTok from publishing third-party content, but that's, again, the substance of the claims, that's just not true. Because by challenging the recommendation algorithm, the state is trying to change the content that TikTok publishes on the platform to make it, less attractive, less enticing, less likely to keep people looking at it. By challenging the autoplay and the infinite scroll features, the state is trying to force TikTok to publish less content. So they are trying to, through this lawsuit, force TikTok to change the way it publishes content on the platform, and that treats TikTok like a publisher. That is exactly what Section 230 was designed to prohibit. These are direct attacks on TikTok's publishing activity, and they fall within Section 230. Happy to answer any Section 230 questions the court has.
I do. It's a Dyroff related question. Okay, right? They adopted the Barnes versus Yahoo test, right? The 3-prong test. But here, I was trying to. that was different, right? A fortunate child ends up dying, right, because of drug overdose, and they say, that the mother tried to do a connection between the application of the rider to the experience project, et cetera. But here, I'm trying to see what your applicability to this case, right? Because I have to look at a motion to dismiss standard, and it's plaintiffs are the master of their complaint, right? And I have to treat their allegations as true. So how are you saying that the dry-off design features and functions case really is applying to this case, and then by extension that the court should, because Nevada courts sometimes look right to federal law, particularly it's the Ninth Circuit, right? So because I don't see that connection, right? There was a pretty tenuous concept, right, of that a provider somehow could be responsible for a son hooking up with a drug dealer, buying drugs, and then unfortunately passing away before that. Here, their allegations are such, but you're saying that their allegations really are heading to something else. Can I look at that at a motion to dismiss standard? Are you contending?
Yes, Your Honor.
Okay,
And let me try and address your question. So it is true that DIROF involved a different, type of platform. And
Totally different type of platform, right? It was an indirect aspect of trying to attribute a drug overdose here by their allegations, which I have to take as true, right?
yes,
They're not saying that TikTok has caused something which they're seeking a remedy for, right? They're seeking a remedy for, in their words, aspects of TikTok.
Right.
So can you kind of
yes.
explain how
So-
you're saying the 230 analysis that they're kind of articulating, taking Barnes versus Yahoo really is applying to this case in the motion to dismiss standard under our state law?
Yes. So I think the answer to your Honor's question is that if you read DIROF,
When I read Dyroff, but go ahead.
yeah, when you read DIROF, it's clear that the Ninth Circuit is looking at the features of the platform that were challenged, because just like the state here, the plaintiff in that case said, the problem with the platform is it recommended this content, and it sent a notification to connect these two users that caused the harm. So in DIROF, as in this case, what the plaintiff was challenging was the features of the platform that they said caused the harm. Now, it's a different type of harm, and that's true, because the facts are different. But it's still a challenge to the features of the platform, which is what the state says Section 230 doesn't cover. And I think the best way for the court to interpret DIROF is to read the way that the MDL interpreted. The MDL decision is obviously bound by DIROF as Ninth Circuit binding precedent, even more bound than this court is.
We're not.
You're not bound at all by
A little
DIROF.
state court judge.
I acknowledge, yes. But the MDL decision in painstaking detail talked about DIROF, Barnes, all the other authority, and said, when you're challenging features, if those features require you to treat the platform as a publisher of third-party content, and that's what the statute says, then it falls within Section 230.
Which is highlighting to where my question was, right? It's that if, right?
Yes,
If you're treating, right, and you're treating as a platform for content, how are you linking that to a motion to dismiss in
Yeah.
this case? That the court should make that, they're calling it a presumption, you're calling it's the law, but okay.
I would invite the court to look at the way they have pleaded their claims, because we are not saying that, they've pleaded their claims one way and we're asking the court to look outside the complaint. They have pleaded their claims in a way that is clear that the features that they target are part of the process for publishing third-party content. So if you look at, let's just on the recommendation algorithm, for example, look at paragraphs 35, 36, 103, and 110 to 112. Those paragraphs, paragraphs of the complaint describe how they allege the recommendation algorithm works. And they don't describe that algorithm as operating in a vacuum. They describe that algorithm as deciding what third-party content to publish. So the court's on a motion to dismiss. I understand the deferential standard, the pleading standard, but they have pleaded their claims in a way that makes clear they are targeting the platform's publication of third-party content because the features they are challenging, they describe in the complaint, publish third-party content. On the infinite scroll and autoplay allegations, that's paragraphs 108 to 109 and 113, same thing. They describe the way that infinite scroll works, not in, a vacuum, but the way that it publishes third-party content. So I don't think the court needs to venture beyond the complaint as well. You just need to take their allegations as pleaded and see that they are describing the features of the platform in a way that makes clear they publish third-party content. Now, they characterize their claims as, no, we're not talking about the content, but they allege publication of third-party content. And so that's squarely within section 230.
Appreciate it. Thank you. That was all my questions. Go ahead, please.
Okay, moving on to the First Amendment, and I will be brief here. The sort of elephant in the room in the First Amendment is Moody versus Net Choice. Just a couple months ago, the Supreme Court decided that case and held very clearly that when a platform curates and compiles user-generated content into its own expressive offering, that is expressive activity subject to First Amendment scrutiny. And the Supreme Court in Moody rejected many of the arguments that the state made in its opposition. Now, the state did not have the benefit of Moody when it wrote its opposition, but those arguments were rejected by and large by the Moody court, which said that using an algorithm to curate and compile third-party content into a platform's own expressive offering is still the platform's expressive activity. And that is what the state is challenging here, TikTok expressive activity. As the complaint alleges it, as the complaint describes, the algorithm analyzes content posted on the platform, it culls from the third-party content, it applies its content moderation protocols, and it curates a feed of content that the algorithm deems beautiful and attractive and expressive. And that feed is TikTok's expressive activity. On the push notifications, TikTok pulls out third-party content. The algorithm makes choices about which third-party content to promote and determines when to convey the speech. Again, this is all alleged in the complaint. And the result is TikTok's expressive offering, and Moody held squarely, there's a holding in the case, that is subject to First Amendment scrutiny. The other binding case from the US Supreme Court is Brown. And we discussed Brown at length in our motion, and it got one sentence in the state's opposition. Brown was about a 2011 California ban on video games. And of course, video games were the hysteria before social media, and California banned a certain subset of video games, and the Supreme Court invalidated that statute under the First Amendment. The court said that basic principles of freedom of speech do not vary when a new and different medium of communication appears. That the First Amendment does not include a free-floating power to restrict the ideas to which minors may be exposed. And the court in Brown made clear that there are certain areas where the state has an interest in regulating. It can prevent obscenity, it can prevent incitement, it can prohibit fighting words, but it doesn't have this free-floating ability to ban all speech to minors and to keep dangerous ideas from them. And so we decided and discussed all this in our papers, and the state had no opposition to it. We think that no matter the level of scrutiny that the state's enforcement action doesn't survive it, we think strict scrutiny applies because the complaint makes clear that the state is targeting content. With respect to each of the features the state challenges, it is attempting to alter TikTok speech. It wants it to publish different speech on the For You page, speech that has a different recommendation algorithm, it wants it to publish different notifications or to prevent certain notifications. That is targeting the content of the expressive activity on the TikTok platform, and it gets strict scrutiny. And the state has not even claimed that it can satisfy strict scrutiny. But even if intermediate scrutiny applies, the state's claims fail because what they are doing is trying to ban speech across the board. They have not targeted particular content on the platform that they say might warrant some sort of restriction. It's not, they're not limiting it to obscenity or fighting words or incitement. They're banning all speech within the realm of what they're challenging. And that's going to include political speech, That's gonna include butterflies and meadows. It's gonna include harmless and beautiful artistic expression. It's gonna wrap in all that because they are not distinguishing between the content that is harmful, they allege, and the content that they have no interest whatsoever in prohibiting. And so this across the board approach is not narrowly tailored to whatever interest the state has in restricting speech. And so it would fail even intermediate scrutiny. And I'm happy to answer any First Amendment questions the board has.
Have any First
Okay.
Amendment questions?
Thank you,
Appreciate
Your
it.
Honor.
Thank you so very much. Okay, counsel, feel free to proceed.
Thank you, Your Honor. Colby Williams for the record on behalf of the defendants. And I will likewise try to move through this quickly, but of course, Your Honor, to the extent you have questions on any of these issues, feel free to stop me. As the court has pointed out, we're here on a 12B5 motion, at least this portion that I'll be arguing is a 12B5 motion, and they're the arguments as to why we contend the state law claims fail. And the court does have to consider well-pled factual allegations as being true, but we would submit on behalf of the defendants, Your Honor, that despite the application of that standard, which we're prepared to address, TikTok does not concede any of the state's allegations have merit. But taking any well-pled factual allegations as true, we submit all of the claims still fail for additional reasons. Let's start with counts 1 and 2. These claims are both brought under the Nevada Deceptive Trade Practices Act, and they both fail for a common reason. And that common reason, Your Honor, is that the statutory scheme requires a sale or lease of goods or services. In order for the statute to apply, there has to be a sale or lease. Here, Your Honor, it is undisputed that the TikTok platform is downloaded for free. There is no exchange of money. And if there's no exchange of money, there's no sale, there is no lease. Your Honor would not be the first court to reach that conclusion. We have cited to you the cases from Indiana. We refer to them in the briefing as Indiana 1 and Indiana 2, where two different judges in Indiana, one at the preliminary injunction stage, one at the motion to dismiss stage, looked at this exact issue under Indiana's version of its Deceptive Trade Practices Act, and it found that downloading the app for free was not a, quote, consumer transaction, end quote, under that state's scheme. Consumer transaction, in turn, was likewise based on the existence of a sale. There was no sale there. There is no sale here. We've cited additional cases, Your Honor, including the Claridge versus RockU case, where there it was downloading a free app. And the Northern District of California said there was no purchase of goods or services under California's version of its Deceptive Trade Practices Act. So for that reason, Your Honor, both count 1 and count 2 fail. But they fail for additional independent reasons as well. Talking about count 1 first, this is a claim that is premised on alleged misrepresentations and alleged omissions regarding the platform's safety. If we're talking about misrepresentations and omissions, we are talking about claims that sound in fraud. Even though this is being brought as a statutory claim under the Act, it is premised on alleged factual misrepresentations and alleged omissions. And Your Honor, if that's the case, then Rule 9B applies, and these claims have to be pled with particularity. Now, if you look at this complaint, despite its heft, there is no allegation in here, or there are no allegations with respect to the who, what, when, where, and how that is required to be pled when you are pleading fraud claims. The same is true with the alleged omissions. There is no allegation about what the omitted material facts were, Your Honor. And so what does the state say in response to this? We don't have to plead under Rule 9B because we are suing under the Act. And what they say is that the Act is remedial and it is to be construed liberally. And it cites to you several Nevada cases from the Supreme Court and the Appellate Court, Betzinger, Poole, and to a lesser extent, R.J. Reynolds. And what those cases say, Your Honor, is that there are some distinctions between pursuing a claim under the Act versus pursuing a common law fraud claim. For example, You don't have to establish a claim under the act by the higher burden of clear and convincing evidence. You don't have to establish knowingly by proving deceit was part of the wrongful actor's mindset. But Your Honor, what those cases do not address are the pleading standards at the outset of a case when a defendant is entitled to notice of what it is being sued for. In every federal court case that has looked at that issue, Your Honor, in Nevada, I'm speaking of, has found that the Rule 9B pleading standards still apply. In those cases, most recently the Austin case, specifically acknowledged the Nevada Supreme Court's interpretation of the act under Betzinger and Poole, acknowledged that it's remedial, acknowledged that it gets construed liberally, but it said you still have to plead under 9B at the outset. And Your Honor, again, I don't have time, nor does the court, to go through all of this, but let me read one example of the problem with the complaint that the defendants are faced with. Paragraph 224, Your Honor, falls under the heading of through public misrepresentation and material omission, defendants lead the public to trust that TikTok is safe for young users. Now let's look at one of the allegations under here. 224 says, moreover, defendants know that any statement regarding the substance of content on TikTok and its appropriateness for young users is also false.
Can I pause you real quick?
Of course,
Second. I was just making sure you said 224, right?
I did say 224.
You may not recall, remember, there's a redacted version of the complaint.
There is, that's the one I'm
So-
holding.
Okay, because the one,
And this is the
I'm-
amended complaint I'm reading from, Your Honor. Recall we filed an
right, you
updated
got the
version.
amending, okay, that's what I wanted, that's why I was quickly checking to make sure you weren't saying something on the redacted portion. No, worries.
Correct.
Go ahead,
And
please.
when I say we, I should say that the state filed an updated complaint, Your Honor. So I'm on 224.
Okay.
And not to bog us down, there are some typos with respect to paragraph numbers, but I think they show up later. And so I don't think that's impacted by what we're talking about here. So to repeat, paragraph 224 says, defendants know that any statement regarding the substance of content on TikTok and its appropriateness for young users is also false. Now, could there be any broader of a statement than we're having to address any statement that's ever been made about the content that appears, Your Honor? I would submit that highlights why the pleading standard of 9B has to apply here. But there are other problems with count 1. The statements that they rely on to challenge TikTok's position on safety are replete with non-actionable statements that constitute opinion, Your Honor. You'll see throughout the complaint, and I can tick off some paragraphs for you, 222, 240, 241, 243, 246. You don't have to look at them now, but we can go over them. What these statements are they are statements that are talking about TikTok's prioritization of safety or its approach to the well-being of its users, the goals that it has for the platform, statements about that the platform supports or that it is committed to. These are aspirational statements, Your Honor. They are non-actionable opinion. They are forward-looking and they reflect corporate optimism. And when we're talking about those kinds of statements, those classically have been rejected as a basis for a fraud claim. And we've cited to you a number of cases for that, but I'll just focus on the Ford Motor case from the Sixth Circuit, which it was a securities case where the types of statements were things like quality comes first. Quality is a top priority. We want to make customers' lives safer. And the court found that those types of statements are non-actionable opinion. They are not misrepresentations of fact. Similarly, in the Lyft securities litigation case, there the court looked at it and said, Lyft didn't guarantee safety. What it said was that it believed in safety, that it thought it was important, and that it was committed to safety. Those were not actionable misrepresentations. And if you look at the paragraphs that I cited to you, Your Honor, that's the exact type of language that they are complaining about. What our goals are, what our commitments are, what our priorities are. Those are not statements of fact upon which a fraud claim can rest. Moving on to count 2, Your Honor. This claim likewise fails due to the lack of a sale. I will not repeat that, but what this claim is seeking relief for, Your Honor, are alleged unconscionable acts. And here, what the state must show is that the defendants took advantage of Nevadans, quote, lack of knowledge, ability, experience, or capacity to a grossly unfair degree. Now, the Nevada courts have not interpreted this language, but we did provide the court with other court opinions that have interpreted this exact language, specifically from Texas. And what the Texas courts have said is this language means that the resulting unfairness that we're talking about must be glaringly noticeable, flagrant, complete, and unmitigated, Your Honor, complete and unmitigated. And what the courts also say is that this is an objective standard. Now, the so-called design elements that are being complained about in the complaint, Your Honor, are standard features that have been available for years. They're part of the platform's infrastructure through which content is filtered. The platform has a set of community guidelines that explain how the platform works. And I would submit, Your Honor, that the state actually pleads itself right out of this claim when you read the complaint. You obviously have to take well-pled factual allegations as true, but let's look at what they say. One thing that the complaint is detailed on is it has an abundance of information about what the public knew about how these platforms work. It repeatedly relies on the Netflix documentary, The Social Dilemma. It cites numerous Surgeon General advisories, and it cites abundant other sources, all explaining how these platforms work. So there was no lack of public knowledge. To use the words of the statute, there was no lack of knowledge based on the state's own allegations, Your Honor. The objective facts indicate that users have ample information at their fingertips disclosing how social media platforms work, including the TikTok platform, Your Honor. And that's not all. With respect to the issue of mitigation, the state again admits in its complaint that the TikTok platform takes steps to mitigate against harm. Again, we have the community guidelines saying what can and cannot be on the platform. There are moderation efforts to take down material that does or content that does not belong on the platform. There are screen time tools to limit the amount of time someone may be on the platform. The state admits all of these items exist and that TikTok enforces them. What the state's complaint appears to be is that we don't do it good enough. And if that's the argument, that we don't do a good enough job of content moderation, then that runs smack in to the Section 230 arguments that you just heard about. And I certainly won't waste time repeating those, Your Honor. So I'm going to move on to counts 3 through 6. If you have any questions about 1 and 2, I'll stop for a moment.
I do not. Thank you.
And I'll try to hustle up through here. Your Honor, counts 3 through 6 are common law and equitable claims. They are for products liability, negligence, and unjust enrichment. They likewise all suffer from a common defect, and that is the state lacks standing to bring these claims. If you look at the complaint, the basis for alleged standing to bring these claims in the complaint is the doctrine of parens patriae. But that does not apply here, Your Honor. That doctrine is reserved for situations where we're talking about public hazards or other wrongs that affect nearly the entire population or the entire population. What that doctrine does not support is the ability of a state to pursue money damages claims on behalf of individual citizens who are perfectly capable of bringing those same claims themselves. And the state has acknowledged Nevadans have brought claims against social media platforms and that they may do so in the future. That's in the complaint. So there's no dispute that Nevadans could bring these claims if they wanted to. So if parens patriae is out, then what's the basis of standing? Because it's the state's burden to show that it can bring these claims, Your Honor, and it hasn't done so. This question is informed by the fact that the powers and duties of the AG have to be spelled out by legislative enactment. In other words, they've got to point to you a statute that allows them to bring these common law and equitable claims. So they try to do that in the opposition. Respectfully, we say that we believe they were unsuccessful in doing so. NRS 228170 is the first statute that they cite, which allows a claim to be brought or defended to protect and secure the interest of the state. Now, Your Honor, again, the state isn't pursuing its own alleged interests here. It's pursuing interests on behalf of Nevada citizens. And when this situation has come up previously under the prior version of this statute in State versus Moore, the Nevada Supreme Court said the state can't use it in the way that it's trying to do so here. What the court said in that case is that the term interest has to be given its plain and ordinary meaning. That case involved the state's effort to set aside a divorce it believed had been obtained improperly. And what the Supreme Court said was, while the state may have an interest in marriage, that interest is not harmed when a private couple divorces. And so you can't use the statute to bring this claim. Here, the allegation is not that the state is allegedly addicted to TikTok. It's that Nevada consumers allegedly are addicted to TikTok. That, Your Honor, is not a basis to pursue these claims under this statute. Under 228390, the next one that they cite, this is part of a series of statutes that creates a Bureau of Consumer Protection and a consumer advocate. It has to be read in the statutes that surround it. When you look at the prior statute, 228.380, it sets forth a series of statutory chapters that the AG can seek to enforce, not common law claims, not equitable claims, statutory claims. So that doesn't help it with these claims either. And last, Your Honor, they cite 598.0963. That comes from the Trade Practices Act statute that we just talked about. We aren't disputing that the state has standing to bring the statutory claims, but it can't use a statute from the Trade Practices Act to support its ability to bring these common law and equitable claims here. Moreover, if you actually read the statute, if it had any application here, it is addressing the types of relief the state can seek, not the type of claims it can pursue. So, Your Honor, I would close with the fact that the state hasn't cited one case that cites these statutes as a basis for it to bring equitable and common law claims seeking money damages on behalf of Nevada citizens. So I'll move on to the independent reasons why these claims fail. Counts 3 and 4 are products defect claims. Count 3, design defect. Count 4, failure to warn. They both fail because the TikTok platform is not a product. This is a threshold issue in any products liability case. It is a question of law for the court under Schuler. Schuler also says that the courts, Nevada courts, have to look to the restatement second of torts to determine whether something constitutes a product. And the focus of the restatement second of torts is on tangible items, Your Honor, physical items. In comment D, it references automobiles, tires, airplanes, power tools, things that are tangible. Here, what we're talking about, Your Honor, is alleged harm that arises from user content. User content is not tangible, Your Honor. It consists of intangible ideas, intangible information, not a tangible product. And even if the state stands up and says, no, we're focused on the platform or the design elements of the platform, all the platform does, Your Honor, is bring those intangible ideas and intangible information to the public. The platform is no more of a tangible product than the ideas and the information it's delivering. So given the clarity of Nevada law on this point, you would think that we would have seen something in the opposition addressing the restatement and addressing Schuler, but it's not in there. The state doesn't even raise those cases or the restatement, Your Honor. What it instead does is it relies exclusively on the Lemon versus Snap case that you heard about earlier from the Ninth Circuit in 2021. But Judge, that case decided one thing and one thing only, that a negligent design defect claim wasn't barred by Section 230. That's it. There is no analysis of whether the snap filter in that case constituted a product. None. And I will tell you why. If you read the whole case and get to the last page, it's very informative. The district court from which that case arose didn't even decide what state law applied. There was a distinction between potentially Wisconsin or California law applying. The court hadn't even determined if which one applied or if a conflict existed. So if there was no determination what state law applied, then you certainly didn't get to any subsequent issues that would have been informed by whatever state law did apply. The case does not help the state at all. Now, we did cite you a SNAP case that does help inform this issue. That's the Zinsick versus SNAP case, Your Honor, from the Central District of California in 2023, which did look at a social media platform and did analyze whether it's a product for purposes of a product's liability claim and found that it's not, because it's intangible, Your Honor. And we've cited you additional cases at pages 33 and 34 of the motion, standing for the proposition that, for example, Airbnb, not a product. Online video games, not a product. The Uber app, not a product. The Meta platform, not a product, Your Honor. For the same reasons, the TikTok platform is not a product, and the product's claims have to be dismissed for that reason. Count 5, and I'm close to wrapping up, Your Honor, is negligence, fails for 2 reasons. No duty, no proximate cause. Starting with duty, of course, the existence of duty in a negligence claim is a question of law. Under Nevada law, there is no duty to protect third parties from the dangerous conduct of others absent a special relationship. There is nothing pled in the complaint to establish a special relationship between the TikTok platform and its users. It's not in there. We have cited to you the Beckman versus Match.com case. It's a 9th Circuit case, 2018, that affirmed a decision from Judge Mahan. And what the 9th Circuit found there is that Nevada courts have never recognized a special relationship akin to that between users and the platform. That's not the only case, Your Honor. The Zinsick versus Snap case I was just talking about likewise found no legal duty was owed to protect the plaintiff from the conduct of third parties, and no duty owed to protect third parties that were on its platform. Now, Your Honor, what did the state say in response to this? Surprisingly, it went back to this Lemon versus Snap case. And the same reason Lemon versus Snap doesn't help on the products claims, it certainly doesn't help on the negligence claims, because again, they haven't even, the district court had not even decided what state law applied. With respect to proximate cause, Your Honor, the state's biggest gripe on this is that proximate cause is a fact question. It can't be decided as a matter of law. Of course, that's not correct. It is usually a fact question, but there are plenty of cases that we have cited to you, including 2 from the Nevada Supreme Court, that affirmed decisions that were based on the lack of proximate cause decided as a matter of law. A harmful act, Your Honor, must be the harm must be the natural and probable consequence of a wrongful act, and it has to be foreseeable in order to meet the definition of probable cause, proximate cause. Your Honor, that chain can be broken if there's an intervening act.
Do you want to reserve some time for your rebuttal? Because right now you're about 10 minutes for your response.
I do, Your Honor. So with that, I will stop there and just say about unjust enrichment, it doesn't apply because of the fact that there is no dispute. A written agreement exists here. And given the existence of the written agreement, you can't bring in equitable claims based on unjust enrichment.
Court has one question which doesn't go to your timing. The question is with regards to the standing argument.
Yes.
There's a difference of opinion between the briefing, right, on who has the burden to show standing. They cite in their opposition that you've cited no case law that says that basically it's their burden to show standing or that there isn't standing, and you state that they haven't shown that there is standing by any case law. So who are you saying on a motion, on the present motion before this court, has the obligation to establish standing?
Your Honor, I thought we had cited a case of standing for the proposition that it is the state's burden to establish standing on a motion to dismiss or at any other time. I believe that burden is incumbent on any plaintiff in any case.
Appreciate that. Was my only question. Thank you. Okay.
You want to take a break, Your Honor?
I'm just was thinking about that, my wonderful team, because remember, you weren't not our first or even our 5th case of the morning. So I think it makes the most sense that we take a 15-minute break, have you come back at 10 minutes to 11, right? Which I've incorporated like this extra time so that we can get done. And that when my team gets their morning break. So see you back at 10 minutes of 11. We are gonna have to ask you to leave the courtroom because otherwise my marshal doesn't get his break because he'd have to oversee the courtroom. Appreciate it. Thank you so much. We are now on the record. It's the red lights are on, so that means red means go. So feel free, counsel, for plaintiff to commence, if you like.
Again, good morning, Your Honor. Randall Jones on behalf of the state of Nevada. I'm gonna, I guess, start by referencing a point you made, during the, defendant's, argument, and, how you commented about, the plaintiff gets to describe their complaint. And is a common tactic. I've certainly seen it many, times over the course of my career where a defendant in a motion to dismiss tries to co-opt what it is that the plaintiff is alleging. And that is, it probably is significant as an effort as I've ever seen in this particular case. Everything I think you heard in all the arguments to some extent was trying to tie our claim back to content. And that just is not the case. And they acknowledge that we expressly disclaimed any intent or desire to try to influence or limit or in any other way impact the content of their platform. But they then go on to say, but we're doing it anyway. And that's just patently not true. So with that said, I'm going to start. I guess I'd like to start with the standard. I know you know it, but I think it's important to reiterate that the motion to dismiss standard is, never pronounced this case right. Trickery.
Archie.
Yes, which is, I think, your case.
I had one version of it, yes.
Yes. And where in the state of Nevada, the court held that you only need to show or make a prima facie showing of personal jurisdiction. Okay, so we also look at the standard 12B5 under Buzzstew versus City of North Las Vegas. Quote, dismissal is only if it appears beyond doubt that plaintiff could prove no set of facts, which if true would entitle plaintiff to relief. Of course, we also know that Nevada recognizes that its long arm statute reaches the constitutional limits of due process. So we've got that. That is sort of the backdrop in which we're making the arguments here today in front of you. And in that regard, let's talk about sort of minimum contacts that defendant could reasonably anticipate. Such minimum contacts that defendant could reasonably anticipate being hailed into Nevada, thereby complying with traditional notions of fair play and substantial justice. And that's the matter of Beatrice is another Nevada case that we've cited for that proposition. None of that is really, I think, unusual in just about any jurisdiction in the country or under the United States Supreme Court precedent as to what you need to do to be able to demonstrate personal jurisdiction. So with that as our backdrop and that very broad standard by which you should evaluate the claims here, I want to talk about the contacts. What did they do? So let me, you would think by listening to counsel for TikTok, that TikTok is some kind of a benign, actually probably a great public service to the world. When if you look at its business model, Judge, what is its business model? This is in essence, and this goes to the heart of what we're alleging, not what they're claiming we're alleging. This is essentially a monster they've created. And I know that sounds a little over dramatic, but think about it. That it has tentacles that reach out. The business model, it is intended to reach out through these tentacles everywhere. And that's part of what their argument here is if we're everywhere, we're nowhere. If we're everywhere, we're nowhere. So you can't get us. And you ask the questions, well, does that mean that the Attorney General of the state of Nevada has to go to California to pursue a claim for the citizens who've been harmed in the state of Nevada? We think not. We think the case law and the statutory structure in the state of Nevada says we don't need to do that, and it would be an absurd proposition to think that. That every attorney general of the state of in any state in the country would have to go to the state of incorporation of a company like TikTok, where they intentionally reach out to that state with the intent. And by the way, we've cited exhibits, we have declarations, we have and I can give you those, there are plenty of them where we talk about exhibits 3, exhibit 6, in our motion. Where we take TikTok's own information, where they acknowledge their business model is essentially intended to reach out to these consumers, wherever they be, so they're reaching out intentionally. Now, they happen to be not just Nevada, but every other state too. But does that mean, because they target every state and every consumer in every state, that somehow or other those people are not harmed in those states when they intentionally target those people? The business model, Judge, is to get eyes on their site, to keep the screen time going as long as possible by those consumers in the states that they have targeted, and have them click as often as they can on things. And they actually evaluate that, and we've referred to that on page 2 of our brief. If you look at that, nearly 1,500,000 Nevadas have created TikTok accounts, which create bilateral contracts. So these are contracts. When, as you know, I'm sure you, as any other consumer that's ever gone to a site, you've got to click that you agree to the terms and conditions of that site. That's creating a contract. And where is the contract being entered into? In the state of Nevada. The resident, including the minor children that we are representing here. So they're clicking, they're creating this contract. So for some reason, that's to them is not a big deal. By the way, you didn't hear any conversation about the bilateral contracts that are being created here every time they reach into our state through the internet, and people saying, okay, only way I can get on their site is if I agree to their terms and conditions. Then they also, as you heard, they court parent-teacher associations. Oh, it was just a Zoom call. So apparently that doesn't matter that one Nevada PTA representative was on that Zoom call when they're basically talking to people about their platform. So there was direct engagement with a PTA person, a parent-teacher association person from the state of Nevada with TikTok. TikTok engages in significant outdoor advertising, as we talked about, including billboards that depict young people. TikTok maintains a presence at the Consumer Electronics Show. Well, apparently that's not important to them, but it's again, on the standard, the court is evaluating this case. We think it's cumulative. All of these various things. TikTok prepared music, BD to host a TikTok lounge at the Las Vegas, or the Latin Grammys in Las Vegas. They invited a singer-songwriter influencer with over 54 million followers to attend the Music Cares Person of the Year Gala in Las Vegas. And this I found really interesting. In one example, TikTok gave a grant to the Howard Wasson Elementary School located in Las Vegas.
Okay, council's mentioning that because I went there probably. No.
Well,
So did my wife, Your Honor.
So did probably you,
I did.
under West Charleston.
It was, although it was called West Charleston. in
Sorry,
those
go ahead,
days.
let me let you finish. My apologies,
No,
there's my disclaimers. Anyone need me to put myself off the case because I haven't gone to Howard Lawson? It was called West Charleston. I won't say what decade. Okay, go ahead, counsel, please continue.
And sending correspondence to the state and copying the Attorney General forward on the letter discussing the Attorney General's safety concerns. So, again, on page 2, we reference how much money that they've made, and they track this information, Your Honor, in the state of Nevada in 2018, 141,000 downloads of their app, generating, according to them, $59,000 in revenue. Then all the way to 2023, 113,000 downloads, generating over $4 million in revenue. So they're making money on Nevada consumers. Their business model is made its whole purpose is to get people addicted to their site. They don't like when you say that, but that's their own documentation shows that that's what it does. And they're doing it intentionally. It's not like this was just serendipitous that Nevada consumers saw their site and got on it. So I think that's important to understand with respect to how they do business. With respect to the Ford case, the Ford Motor case we were talking about. This in footnote 4, with they reference footnotes 4. I want to read what it actually says. And we do not here consider internet transactions which may raise doctrinal questions of their own. In other words, they never addressed the issue that at least was suggested they did in that case. In Piccoli versus 8th Judicial District Court, the court found it is not necessary to have physically entered the state. A phone call can be physical presence. Well, here we have hundreds of thousands of direct contacts with their platform by Nevada consumers in Nevada. And by the way, to suggest, it's almost as if they're suggesting somehow or other they're doing this gratuitously as some kind of a charity. They're making money, Your Honor, on this. And they say, well, we don't charge for this. And I'm kind of jumping ahead a bit, but understand that, and I'll get to the consideration aspects later with respect to the sale of a product and whether you can have a product liability case without a sale. But if you look at our statute, it talks about consideration, any other consideration. Well, Your Honor, in this day and age, I think it goes without any question. I don't know, the court would take judicial notice of it, but data is what they're acquiring from the consumers in Nevada. They're acquiring their personal data. They're acquiring their what they like, where they live, how long they're on the site, all of which goes to their business model. The consideration in this case is the data that they acquire when they accept the terms and conditions of that app and sign on to TikTok. So there is that consideration is, and by the way, just again, skipping ahead, the Indiana case they cite, that's a different consumer protection, deceptive practices definition. It's not the same as Nevada. So, and by the way, that's the only other case we're aware of where that has occurred because they have a different definition of what a sale may constitute. But in this case, we have a much broader definition and includes any consideration. So, with respect to the bilateral contract as well, I should mention that you're downloading the app. There are presumably cookies that are installed on your system when you download that app. They track your use. This is all admitted. They don't deny. They track the use. Then they entice the users to use more, and the more they use, the more profitable that user is to them with their advertisers. And again, with respect to the Ford Motor case and the distinction they try to make that advertising as the Supreme Court held, where you live is where you see them when talking about their advertising, about their billboards, and they made a distinction. Well, Ford has dealerships in those cities. Well, Your Honor, those dealerships are not owned by Ford. Those dealerships are owned by local business people who buy Ford products from the Ford company from out of state. So I think that's a distinction without a difference in this case. And then I wanted to cite it's on page 9 of our opposition, but I think it encapsulates this point very well. It's the Arkansas court. I know it's not precedential in this case. I'm just offering it for a good description of, I think, what's going on here. TikTok advertising to Nevada consumers, in this case, Arkansas consumers creates a forum-specific experience. In other words, their advertising for these people creates a forum-specific experience. So there is that direct connection. And by the way, do you have any questions about that, Your Honor, before I go on?
Realistically, they address both general and specific jurisdiction in their motion. I saw your motion, your opposition focused more on specific
Yes.
jurisdiction. Are you contending that they've kind of acquiesced to general jurisdiction or?
I don't know if they've acquiesced to general jurisdiction. I don't want to put words in their mouth. We certainly think that we have jurisdiction over them, whether it be specific or general. I don't know if that answers your question. Probably not.
No worries, go ahead, please.
Okay. I want to talk about they talked about, well, first of all, do you have any other questions about the jurisdictional issue?
I do not, thank you so much.
So with respect to section, well, let me talk about fraud first in Rule 9(6). We don't believe, and by the way, I don't think they've cited any Nevada case law that says that that we have to plead to a Rule 9(6), 9B standard in a Deceptive Trade Practices Act. We did state that Rule 8 is not subject to Rule 9 specificity. And as I already said, in terms of the harms that we believe constitute the fraud, I believe there's, gosh, how many? Question. There are too many notes here, Jan.
Of course.
Oh, also, I would mention with respect to consideration, it's paragraph 131. TikTok also sells coins to their users, which can in turn send to their favorite TikTok video creators known as GIFs. So that's additional consideration, and certainly under a motion to dismiss standard, we believe that's sufficient to pass muster on the motion to dismiss. But the other point I wanted to make with respect to the alleged misleading conduct, and Mr. Williams referenced in what I would consider cherry-picked certain allegations and misconstrued what we're alleging there. But if you look at paragraphs 220 through 282, that's 12 pages where we talk about the various misleading conduct that TikTok has entered into in this case. TikTok claims, we believe they lied about the safety and efficacy of their platform and their marketing, including the billboards, which you already talked about. You know, for a motion to dismiss standard, we've got 12 pages of allegations where we have stated what we believe to be their deceptive trade practices under the statute. And with respect to that issue, TikTok is embedded within their platform design features. And by the way, I want to make this point. Design features are not algorithms. They are not content. It's a design feature. It's a feature that it's basically code, if you will, that TikTok has created that creates features that apply to the consumer's use of their platform. So for them to try to mix up these words like algorithm and embed them in a design feature is just simply false. And so I don't want the court to be misled by their argument of trying to describe or explain what our case is about. That is not what it's about. We reference, I think, on 2 paragraphs early on in the complaint, and I think in paragraph 32 or around there, where we talk about algorithm, but that's just talking about the business that they're in. It's not talking about the claims that we're making. And there is a distinction. For example, some of the design features that are used to maximize young engagement. I'll just go on from there. Young engagement means essentially synonymous with addiction. Trying to get these young kids to be addicted to their platform and use it as long as possible, stay on their platform as long as possible. Low friction and variable rewards is one feature we talk about. Social manipulations, ephemeral conduct, push notifications, harmful filters, and ineffective and misleading parental controls and so-called well-being initiatives. So these are the design features that we also believe make this a defective product as well. So, and by the way, they sought to hide its knowledge of these harmful qualities from Nevada consumers. So at this point, I'm going to talk about the section 230. And I'm going to start talking about initially with the Good Samaritan, so-called Good Samaritan section. And again, we did cite Lemon, the Ninth Circuit case. The platform, where they basically say, the Ninth Circuit says that these, in that case, it's a different product, but they said it is a product. And I would use sort of an intellectual property analogy to this. So you ought to think about this. So TikTok has its platform. Well, what is that platform? That platform is at a minimum, it's intellectual property that they want to protect very closely. They don't want anybody else to use their product. Or what are they going to do? They're going to sue them. They're not going to allow somebody else to take their product and use it without taking action. They treat that platform as their product. And so that's why I believe the Lemon courts looked at this and said, hey, look, this is when you're not talking about content, separate and apart from what is being published by third parties. This is something of their own design and creation. These features are something that TikTok created and utilizes to engage with, and we submit, addict Nevada consumers to their platform. It really has nothing to do with the information that is being provided to the consumer. It's on their platform. It's their features that the consumer engages with. And if on page 13 of our brief, we cite a couple of pages of the complaint, paragraphs 173, 174, and 175, where we expressly state, and I'm quoting in 173, the state does not challenge or seek to curtail the publishing of any specific type of third-party content by challenging the above described addicting and harmful design elements. And you'll note we go on to talk about the design elements, and I just mentioned them. And the substance of any content incorporated into or used by the design elements is immaterial to our claims. So again, Your Honor, the defense cannot redefine what we're alleging in order to prevail in a motion to dismiss. That would be totally improper. So just because they're calling it something doesn't mean that's what our allegations is. And this court needs to look at the complaint we've drafted and the allegations we've made and consider the plain meaning of those allegations, not their take on those allegations or their attempts to spin our allegations. And paragraph 175 goes on to say, regardless of the substance of any content on TikTok, either first or third party, the purpose of the design elements is to extract additional time and attention from young users whose developing brains were not equipped to resist these manipulative tactics. So those are our allegations, not their spin on our allegations, and that's what this court needs to consider and construe in determining whether or not we survive a motion to dismiss. And by the way, I would just point out that section 230 has nothing to do with design. It is all about, essentially content and speech, and that's not what we're talking about here. As was referenced in the social media's cases that we talk about on page 15, and here I'm quoting a reference by the court to section 230. Quote, the features themselves allegedly operate to addict and harm minor users of the platform, regardless of the particular third-party content viewed by the minor user, end quote. And that's at page 15, starting at lines 14. And as I talked about in Lemon, the Ninth Circuit Court essentially held that that's reward system and the speed filter, and that, quote, Snap could have satisfied its alleged obligation to take reasonable measures to design a product more useful than it was foreseeably dangerous without altering the content that Snap users generated. So I think that's a very appropriate summary. Essentially what the Ninth Circuit held in that case is, look, you can change your features in a way that is not unreasonably dangerous without affecting the content. So that's why we think their position is just simply trying to misconstrue our allegations and what we're alleging in our complaint, which we specifically disavow, by the way. Lemon Court went on to say, quote, the duty to design a reasonably safe product is fully independent of Snap's role in monitoring or publishing third-party content. That goes to the heart of our position and directly contradicts TikTok's position that we are trying somehow to moderate or influence or impact the content. And by the way, that reference in Lemon to design a reasonably safe product, again, speaks to the negligence elements of our claim as well, in terms of.
Pause you for a quick second,
Sure,
there, right? Because counsel, right, for TikTok stated that in Lemon, the only issue that the appellate court actually addressed, right, was the 230 claim, right? Because they use the language that, Snap has also urged us to affirm the district court's decision on the alternative ground that the parents have failed to plead adequately their amended complaint, the causation element of their negligent design claim, that we may affirm on any ground supported by law. We decline to exercise that discretion here for 3 reasons, and they give the reasons. So are you contending that the Lemon versus Snap case, the Ninth Circuit, did address the negligent design, or that it was purely a 230 claim?
Well, I think it was a 230 claim, but I think it's instructive with respect to negligent design. And the reason I think it's important is because it really what they did, at least as far as I can tell in reading, is that they made a common sense, did a common sense analysis of what a duty would be if that issue was before them. So whether it's and by the way, since it's Ninth Circuit, the court is not compelled to follow it anyway. But it is a Ninth Circuit case. And so since we're in the Ninth Circuit, certainly as this court I know is in the past, and especially when there's a lack of other authority that the court can look at, we'll sometimes consider Ninth Circuit precedent as important and instructive. And so I think that's really the point I was trying to make, Your Honor, okay. Not specifically that they held it back.
No, go ahead, please. Thank you so much.
I'm sorry.
Oh, thank you so much.
Oh, sure. So with respect to the 230E3 Communications Decency Act, and by the way, this is my failure, but in getting prepared for the argument, I came across Irwin versus State, and so it's not in our briefs, but as I think I have an obligation to the court to mention controlling Nevada law if I think it exists. And so Irwin versus State, I believe, is relevant, and it's at 111 Nevada 1535. It's a 1995 case. And it essentially says that commercial speech which concerns unlawful activity or is misleading is not protected by the First Amendment, and the state may freely regulate it. So we believe this is all commercial speech, and therefore assuming that this has anything to do with content, by the way, because our position is, again, I'll say it again and again, because they said again and again and again, it's all about the content. It's not. And they cannot define our allegations to suit their motion to dismiss. The court needs to look at what we said and what we've alleged, but to the extent that the court even wants to consider that argument, that somehow it would be content, Irwin says if it's commercial content, it's not restricted. And assuming there somehow is, or the court believes there somehow is a connection to content here, the First Amendment also does not apply as, or if it does apply, the state's claims satisfy intermediate scrutiny. The claims here deal with content neutral restrictions that impose no incidental burden on speech, and that's the Turner Broadcasting case that we've cited as a Supreme Court case. So in other words, because we are contending these are design features, have nothing to do with the content that the site is, or the platform is forwarding to the consumer. To the extent there is any effect, it's incidental to the First Amendment, because it's really all about the design features, not whatever content is being pushed through by those design features. And if I can, I want to move now to the issue of product liability, strict product liability. And we're referencing their NRS 598, and I'm sorry, I'm talking about the Nevada Deceptive Trade Practices Act. And this is where I talk about the sale. If you look at the statute itself, in this case, I'm referring to 598094, quoting here that the sale includes any sale, offer for sale, or attempt to sell any property for any consideration. And in our complaint, we talk about, and this is in paragraph 55 of the complaint, quote, we use your information, this is quoting from TikTok, to fulfill and enforce our terms of service. We may also use your information to, among other things, show you suggestions, promote the platform, and customize your ad experience, end quote. So the consideration is, again, as I mentioned, if you don't even consider the coins that they offer to their Nevada residents, the consideration is the data that they're collecting from the consumers by utilizing the site. I would also reference the Reynolds versus Tobacco Reynolds Tobacco versus 8th Judicial District Court, where the court held that a consumer need not actually purchase or use a defendant's product to state a claim under the NDPTPA. The plain language of the NDPTPA contemplates situations in which liability may be found even when, like here, an individual did not actually purchase or use the product. Again, to the extent that that is an issue, our Supreme Court has addressed it. Again, goes on to say, that court goes on to say, quote, even if a plaintiff did not use the manufacturer's product, so long as a plaintiff can still show a direct harm arising from the manufacturer's deceptive trade practices, end quote. So we, again, believe that they have established that there is consideration here under both the statute and the facts. And with respect to the undisclosed facts that we are alleging, it's in paragraphs 91 through 92. This is from TikTok's own reporting, internal documents, that the platform can become habitual or excessive, can lead to deficient self-regulation, including negative life consequences that cause negative mental health effects, including loss of analytical skills and memory formation, and contextual thinking, conversational depth, empathy, and increased anxiety, leading to interfering with lack of sleep, work and school responsibilities, connecting with loved ones. So these are things that, and here's the point, Judge, deceptive trade practice. These are things that TikTok knew about its own design feature. So they knew this and they didn't tell. So there's a misrepresentation by omission. They didn't tell the consumers. And then they go on, but then they double down, and then they actually have initiatives called this well-being initiative. So they're telling people that these things are going to make your life better, without telling them the actual harms that they know from their internal research is going to happen to their customers. Do you have any questions about that, Your Honor?
I do not, thank you.
And with respect to, Mr. Williams talked about the pool case. I think that we think the pool case is relevant to this litigation, and I'm citing it here where I say from pool, quote, because the Nevada Deceptive Trade Practices Act is remedial statutory scheme interpreting knowing, quote, end quote, knowingly to require more than a general intent would render the NDTPA and common law fraud claims redundant, disserve the NDTPA's remedial purpose, and discourage claims by forcing parties to clear a significantly higher bar. Point again there being that we don't believe that the greater specificity under Rule 9B is required for the NDTPA under the pool case. With respect to unconscionable practices claim, NRS 598.09231E. As you saw, the definition is unconscionable practice is an instance where a business takes advantage excuse me, of the lack of knowledge, ability, expertise, or capacity of the consumer to a grossly unfair degree. Again, if you take our allegations in a most favorable light and assume that they are true, we're talking about the parties we're representing here, the state is representing, is minors, children 17 years old or younger. And when you look at what they've done, where TikTok is purposely targeted, including minors, and we've got the evidence from TikTok that I've recited to you early on in the discussion of their own statistics. There's approximately 400,000 minors that they have on their platform in the state of Nevada, over 400,000 minors. So the question is, does this court think there's sufficient basis on the pleading stage to go forward and whether or not we can ultimately make a claim? Again, this is based upon their own admissions in their own reporting that there has been an unconscionable practice where a business, in this case TikTok, takes advantage of the lack of knowledge, ability, and experience or capacity of the consumer to a grossly unfair degree. Well, so it's one thing to do what they've done to adults. It's a whole nother matter to do it to children. And so we certainly think at the pleading stage, we have provided more than sufficient evidence, especially because we've been able to acquire some of TikTok's own internal reports that demonstrate the very point we're trying to make, that it seems to me falls directly within the confines of the statute itself to make out a claim for unconscionable practice claim. With respect to the Attorney General's standing, one thing I would just mention is the complaint, and this is in paragraph, page 36 of our brief.
Right, Council, what paragraph? Did you say 3-6?
Paragraph 36, page 36 of our brief at lines 9 to 10. You'll see there's a reference to the consumer advocate as a sole discretion to represent the public interest in any class of consumers in any proceeding. If you take a moment, catch up here.
Right, but that's the 598 analysis, right? Isn't the citation to 598?
Yes, the reason I bring that up is because you'll note in the complaint that the complaint has also been brought by the consumer advocate for the state of Nevada. Oh, I'm sorry. Thank you. As Mr. Gaines just pointed out, it's at page 36. Starting at line 9, we actually reference section 228.391A. That's where I was quoting.
Okay.
That's where it talks about the consumer advocate.
Mhm.
So the other point I would make is there's no case law that council's been able to cite, which indicates that the Attorney General does not have standing in a case like this to represent the minor children in the state of Nevada that have been harmed by deceptive trade practices, particular by deceptive trade practices, or negligent actions, strict product liability. So there, as far as we can tell, there's nothing that suggests that the Attorney General does not have the authority to do that they've cited to. And we believe that if you look at 598.0963 subs 3, quote, the Attorney General may bring an action in the name of the state of Nevada against that person to obtain a temporary restraining order, a preliminary or permanent injunction, or other appropriate relief, including without limitation, the recovery of a civil penalty, disgorgement, restitution, or the recovery of damages. Again, we think that 598.0963 does provide on its face the Attorney General that authority. Do you have any questions about that, Your Honor?
My question on standing is going to be for the negligence claim and the unjust enrichment claim.
Okay.
So you're asking me about standing. Yes, I have a question, but those are the claims I have a question on.
Well, so I guess my point would, my response would be that there is nothing to suggest that in a parents patriae claim that the Attorney General does not have the ability to represent minors in the state of Nevada where a party has committed a negligent act against those minors. Another thing I want to reference, Your Honor. Since we're kind of at that point, I talked about the duty of care. Thank you. Actually, Mr. Slade made a point here, and actually is a case that you know a little bit about, is the opioids case. In that case, there were negligence claims brought by the state of Nevada through the Attorney General's office against the manufacturer and distributors of opioids. So there is case precedent here, and at least in this courtroom, for allowing those kind of claims to proceed.
I was thinking of that when I was asking the question. However, I went back historically to see if that was ever raised as an issue. Because remember, I took over that case from Judge Gonzalez, and she retired.
Right.
So I have most knowledge, but not, hear his. I didn't see that it was.
Your Honor,
I'm not gonna go back. I mean, please, I've got hundreds and hundreds of cases in my dockets. There's been thousands of hearings I've had since I've addressed certain opioid issues, but that's why I was asking the question, because I was like, oh, well, that was gonna be my question on the standing issue on the 598, because we already dealt with that. with the design defects and opioids and things like that. That one was addressed. So I was gonna ask you all a question on that, but that's what I was focusing on. Negligence, I didn't see that that was brought to the court as being something disputed. Once again, like I said, I've had thousands of hearings since those, so I'm not saying it's perfect. I didn't see it, but go ahead. Feel free to
I
continue.
guess-
We've got a few more minutes, because then I'm
Well, the
gonna have
other
to
thing-
circle back to.
Sure.
council counsel.
The other thing I would refer the court to is NRS, and it's in our brief on page 36, 228.170 sub 1, where the statute provides, quote, "To protect and secure the interest of the state, it is necessary that a suit be commenced or defended in any federal or state court. The attorney general shall commence the action or take the defense, or make the defense, excuse me." So there is some statutory support for the argument that there was no limitation in that statute as to what type of claim that the attorney general may bring. We also cite Ryan versus a judicial district court, holding that, quote, "The legislature made clear its intention that the authority of NRS 228.170 embraces only civil matters," end quote. Well, this is obviously a civil matter. So I think by sort of, if you will, exclusion, then criminal matters would be excluded, but they're essentially saying that civil matters would be allowed. I hope that answers your question, Your Honor. And I don't want to belabor this too much. We've already talked about Lemon and when we talk about duty of care in terms of the negligence context. I think it is instructive to see what the Lemons court said about duty of care. But I would also think that if you just apply just general negligence doctrine to a claim like this, I would assert that a company like TikTok, who puts a social media platform out there to consumers, has a common law duty not to put out a product, because I don't know, I mean, they can call it whatever they want, but at the end of the day, that is their product. That is what they sell. They're selling the consumer an experience on their platform, where they gather the consumer's data, and then they use that data to make money. So through advertisers. So I would suggest that it only makes sense that if you're going to do that, if you're going to take that upon yourself to put a product out there to the consuming public, and especially when you're talking about minors, you have a duty of reasonable care. And if you reach that duty, if you put out a product that is unreasonably safe, or excuse me, unreasonably dangerous, it can create a liability for you. So I think, again, at the pleading stage of this case, we have sufficiently pled a negligence claim. And again, just from a semantic standpoint, the fact that TikTok doesn't want to describe what they're selling as a product doesn't make it not a product, doesn't ignore, or excuse me, doesn't create a situation where they're not selling something to the public. They're certainly, there's an exchange going on here. We'll give you our access to our platform in exchange for you giving us your data. With respect to proximate cause, that's an issue of fact, Your Honor. I don't know how much you want me to go into that. Has no place in a motion to dismiss situation or argument. So at this stage of the proceedings, we believe we can certainly show that there is a natural and probable consequence of the negligence or wrongful acts that were not just should have been foreseen by TikTok, that they actually were foreseen because of this research they've done. So we certainly think we can demonstrate proximate cause if we need to, but we don't believe we are required to do that at this stage of the proceedings. With respect to unjust enrichment, I would just simply reference the court to Rule 8D3. We're entitled to do alternative pleadings at this stage of the case. Also, they argue that, you know, there's bilateral contracts. We talk about the bilateral contracts between the consumer, in this case, the minor, and TikTok. And they say, well, you can't have these contracts. You talk about these bilateral contracts and have an unjust enrichment claim. Well, we think that Rule 8 D3 does allow us to do that, but I would also make this point. There's no allegation, and nor is there any evidence that the Attorney General has a contract with the with TikTok. This is a parent's patriotic claim, so we don't think that applies either. And then the only other point I would make is we do have counter motions to the extent the court thinks it's necessary on personal jurisdiction. I think the evidence.
Talk about your counter motion to engage in discovery, jurisdictional discovery.
Yes, and a motion to amend if necessary, a motion for leave to amend if necessary. Your Honor, you know, in this case, I believe that there's somewhat unusual circumstances in that we've been able to get a substantial amount of information from TikTok in preparation of filing a complaint, demonstrating through their own records, their own research, their own investigation of their customers, information that shows, you know, all the things we believe they've done that are actionable. And so, and also the contacts with the state of Nevada, the intentional directed action towards consumers in this state that they have tracked, they have analyzed, and they use to make money on. And so from a personal jurisdiction standpoint, we certainly think we have demonstrated more than sufficient evidence of specific jurisdiction in this case for the specific claims that have been alleged in this case. So there's no need for any further discovery at this stage of the proceedings. But we did make that counter motion as out of an abundance of caution. We think this, in fact, I think Mr. Williams talked about the heft of our complaint. We tried to be very thorough. As you know, it is a pretty comprehensive complaint.
89 pages.
And it has with very specific factual allegations, referencing very specific information derived from TikTok. So we think that they are more than on notice of what our claims are about. And to the extent that they get up here and say it's all about content, well, that doesn't mean they don't know what the claims are about. They just want to misconstrue them or mislabel them so they can get out of this case. But there's been no suggestion that they're not fully on notice of what the allegations are and how they've misled the minor consumers that we represent. So I don't think there's any need for any further clarification of the allegations in the complaint. But out of an abundance of caution, we have made that counter motion.
Appreciate it. Thank you so very much. Okay, counsel. Are you dividing up your 8/9 minutes, or are you taking it all?
I will endeavor to leave a minute or so for Mr. Williams.
Generous, go ahead.
Yes. Well, I want to begin with the court's question on personal jurisdiction about what other states have done. And I misspoke when the other states have, when I said that other state attorney generals have sued TikTok, they've sued Meta. There are.
You have to realize I have that case too.
I know, Your Honor is familiar with this, but 35 states have sued Meta in California for claims that are essentially the same claims as these. And those 35.
I understand I cannot discuss any other cases that are currently pending in this court. I make no rulings on any other case, even though
Certainly.
reference to my opioid case. Go ahead.
Certainly, Your Honor. And I'm not talking about the cases before this court. I'm talking about the cases that attorneys general have brought in California. And that's attorneys general on the
Right,
East
but we're on
Coast.
TikTok. That's why I asked the TikTok question.
Yes.
I'm familiar with Meta. That's why I was
Okay.
asking my TikTok question.
Okay, so those are not claims against TikTok, those are claims against Meta, but the point is the same. That attorneys general file enforcement actions in the home states of defendants all the time, where there is a personal jurisdiction problem with suing the defendant in the attorney general's state. That happens all the time. And the state has Arkansas and Texas counsel. In this case, they could have just as easily associated California counsel and brought the case in California where TikTok is at home. Mr. Jones mentioned bilateral contracts. There's no claim arising out of those contracts. He mentioned billboards, Latin Grammys, the Consumer Electronics Show. There are no claims arising from any of those contacts. And the argument that I heard, and it's the same argument that's in their papers, is that you have to view this cumulatively. That you look at all these contacts together, and even though the claims don't arise out of any of those contacts, at some point there's just enough contact with the state that there's specific personal jurisdiction. And that is exactly what the Bristol-Myers case, the United States Supreme Court, 2017, that's exactly what the Supreme Court rejected. I'm just going to read 2 sentences from that opinion. For specific jurisdictions, page 264 of the opinion. For specific jurisdiction, a defendant's general connection with the forum are not enough. As we have said, a corporation's continuous activity of some sorts within a state is not enough to support the demand that the corporation be amenable to suits unrelated to that activity. So it is just wrong as a matter of law that you can aggregate all these contacts and consider some point at which there's enough contact with the state that for specific personal jurisdiction, that is just wrong as a matter of law. Also point the court to the Johnson versus Huffington Post case, page 324, where the Fifth Circuit makes the same point, distinguishes the Ford case on this ground. Mr. Jones suggested that there is a claim for general personal jurisdiction here. And I just want to make clear that that is not the case. They did not argue general personal jurisdiction in their opposition, and there would be no basis for that. General personal jurisdiction is only available where the defendant is at home, meaning where their principal place of business is, where their headquarters is, or where they're incorporated, none of which is true of Nevada. So there's absolutely no basis for general personal jurisdiction. On section 230.
And can I stop you there?
Oh, of course,
So
yes.
you saying that because your contention is that there's not general personal jurisdiction, that precludes this court from continuing with the case?
So
I'm just trying to get the clarity of what your position is.
our position is that there is certainly no general personal jurisdiction, no basis for this court continuing with the case on that ground. And on specific personal jurisdiction, we think the same is true, and that the court does not have jurisdiction to adjudicate the state's claims against TikTok under either general or specific personal
I'm
jurisdiction.
gonna pause you for a quick second. I'm just gonna ask from plaintiffs, because I just want clarity, right? Because that's why I asked the question, because it was a little unclear.
Of course.
Counsels for plaintiff, are you contending general jurisdiction as well? And if so, what page in your opposition would that be?
We are not. And when you asked the question, I basically was sort of deflecting, but no, we think this is a specific jurisdiction case based on the arguments and the evidence we presented.
Thank you. I just, it's clear what was actually before the court. Wanted to make sure.
Super
we're all
helpful.
on the
Thank
same
you, Your
page for what? Okay, go ahead, please.
So on section 230, Mr. Jones said that we are mischaracterizing the complaint, and I definitely don't want to do that. I referenced these paragraphs in my topside argument, but I just want to read them, a couple sentences from them to make clear what we are pointing to as their allegations that describe publishing of third-party content. So this is in paragraphs 103 generally to 112. This is the section of the complaint where they describe the design features that they are challenging in this case. Paragraph 103, TikTok employs the endless scroll, supplying young users with unpredictable variable awards by strategically and intermittently surfacing content that defendants predict users will want to see. But defendants are not just making a lucky guess about the type of content that children and others would wish to engage. Paragraph 108, this is talking about the autoplay feature. Another form of navigation manipulation called autoplay is similar to endless scrolling. Like TikTok, other social media platforms like TikTok that provide video content for users. Simply put, once one video is over, another one begins without any further prompting from the user. Paragraph 109, 110, 111, 112, same thing. The 112, the algorithm tends to serve more and more similar videos as shown in this internal presentation. So it is just not true that the complaint does not describe the publication of third-party content. It's littered all over the complaint. There are over 120 times in the complaint where the complaint uses the term content. Over 120 references to content in the complaint. And there are dozens, if not hundreds more, references to videos, posts, notifications, which of course are also other words for content. So it's just not true that this complaint doesn't describe the publication of third-party content. Lemon versus Snap, I addressed this in the top side argument. The Ninth Circuit said very clearly that the reason that that case fell outside of 230 was that it was Snap's content and not third-party content. It did not say that section 230 does not apply to features. And I would point the court to the Bride versus YOLO case decided last month by the Ninth Circuit. That's 112 F 4th 1168. The Ninth Circuit distinguishes Lemon on that very ground.
And that's in what page of your brief?
It was decided last month, so after briefing had closed.
Right, so how can distinct, right, from bringing something that's law here in Nevada, right? Here you're just asking the court to address something that you're saying is persuasive, not controlling, correct?
That's correct, Your Honor, and the
Has
most,
counsel for plaintiff had an opportunity to address that case so that the court could consider it? That's where I really, my essence, my question is.
I don't know whether they've read it or not. It hasn't been briefed because it was decided after briefing closed. I'm merely citing it to the court as the most recent authority from the Ninth Circuit, which distinguishes their authority as they described it, in their argument. So it's responsive. Yeah, okay. So moving on to the First Amendment. I was shocked that Mr. Jones in his argument did not even mention Moody versus Net Choice. This is controlling on-point authority from the US Supreme Court decided in the last couple months that holds directly that internet platforms that curate and compile third-party content into their own expressive offering triggers First Amendment scrutiny. I mean, I'm not going to re-argue my Moody point, but I'm just shocked that we didn't hear anything about that because that is directly on point recent case law. There have been decisions since Moody, including out of the District of Utah, that have applied Moody to challenges to features, much like the ones the state challenges here. This is just on point authority that the state has not even tried to distinguish. Instead, they cite a 1995 decision, which, again, was not included in the briefing despite being 30 years old, that obviously has nothing to do with the application of the First Amendment to online interactive internet platforms. Moody versus Net Choice is the case, and we think that it governs here and requires and triggers First Amendment scrutiny and requires the claims be dismissed. I'm happy to take any questions the court has on.
I do not have any. Thank you so much, Scott.
Okay, thank you, Your Honor.
Your Honor, I'm not sure how much time I have, so let me start by asking, is there any question that the court has that it would like me to address right out of the box?
Realistically, I'm the same question as I told you I was, right? The standing question, because under the products concept, you would be under the products concept, unjust enrichment and negligence. You heard response of plaintiff's counsel. I mean,
I did, and so let me start there, Your Honor. I heard citation to the same three statutes that I addressed in my opening presentation. And Your Honor, quite simply, reading those statutes, none of them authorize the state to bring these types of common law or equitable claims, if you read them. The 598 is the easiest one because it deals strictly with deceptive trade practices under that part of the statutory scheme. The other two create a consumer advocate, but Your Honor, it's got to be read in conjunction with the statutes that surround it, which specified the statute. And the other one dealt with something in the public interest of the state, which I think is very similar to the Parents Patriot. And the law is clear that you can't bring those types of claims based on harm to individual, alleged harm that is, to individual Nevada citizens. But what those claims or those concepts are directed at is harm to the entire population. And so for those reasons, I don't think that they've provided you with any statutory authority to say why they can bring this subset of the claims. And it is their burden, Your Honor, I would submit. Moving on very quickly, unless I
no, that's it. I want to make sure you get your 2 minutes. Go ahead.
Right. So with respect to the products liability claims, Your Honor, I heard no reference to the restatement second. The Schuler case tells us that's what Nevada courts have to look at to determine whether something constitutes a product. Most respectfully, looking at Lemon versus Snap is not what this court should be doing for a couple of reasons, because it is not the restatement second, and it never addressed the issue of products for the reason that I stated earlier. With respect to the Deceptive Trade Practices Act claim and specifically the issue of the sale, Your Honor, they say that any consideration counts, but let's look at the definition of sale. Sale means any sale, offer for sale, or attempt to sell any property for consideration. Now, I'll admit it's somewhat of a confusing definition because the term being defined is used repeatedly throughout the definition itself. But Your Honor, number one, I don't know what the property is here. That's never been identified. And we cited to you the Webster's definition of sale, which is a transfer of ownership for a price. That simply has not occurred here, Your Honor. And if user data could constitute consideration to satisfy the definition of sale, then literally anytime any of us go to the internet and click the button to either accept cookies or confirm my choices, then that website operator is engaged in the sale under the Deceptive Trade Practices Act, whether it's intending to sell anything or not. And respectfully, I submit that's just too far of a broad reading for that statute. Would, be respectfully an absurd interpretation of that statutory provision. Your Honor, very quickly on the other points, then again on negligence, Your Honor, the Snap versus Lemon case is what we heard to support the concept that a duty exists here. For the reasons I've said before, it doesn't. But if they tried to bring the focus to the platform itself and owing a common law or a general duty is what I heard. But the design elements themselves, Your Honor, in and of themselves are meaningless in a vacuum. There's no allegation in the complaint that the design elements or the platform itself is addictive. If the design element in the platform sent people to a blank space, there wouldn't be any claim of alleged harm. The alleged harm is the referring users to other third-party content. And so I don't think they get there with this alleged general duty or a common law duty. And finally, with unjust enrichment, Your Honor, they talk about it being an alternative claim, but usually it's an alternative claim to a breach of contract claim. Usually someone comes in and says it's a breach of contract. And if the contract for some reason isn't valid, then they seek relief on unjust enrichment. There is no contract claim here. What the state's trying to do is step into the shoes of the users who are a party to a contract and seek to recover a benefit under that contract. That's why they can't do it under unjust enrichment.
Okay, appreciate it very much. Thanks so much. So
I get, as it relates to the, my counter motion?
have
I need
it,
to, if your court's gonna rule, I don't, gonna rule in my favor, I definitely don't need to.
okay, well. You get a minute on the counter motion, 2 minutes, same 2 minutes, fairness aspect. Go ahead.
Well, I just say from the standpoint, even from here, under NRCP 17A2, the real party in interest, when a statute is, a statute so provides an action for another's use or benefit must be brought in the name of the state. So there's an authority here that allows the Attorney General to do it. And even Mr. And the reason I bring that up in terms of an amended complaint is we don't think that, again, they've raised any issues. They talk about content. They're trying to interpret our complaint and what we've alleged. And some of the last things that Mr. Williams said were all factual arguments about what they believe. Actually, all counsel for TikTok in their counter arguments, they're arguing what our complaint says or doesn't say. So I don't think we should have a need to amend, but if the court feels it's appropriate, we certainly can do that. But what their arguments have been essentially are arguing the facts and their interpretation of the facts, and that would not give rise for us to need to amend, I don't believe. Thank you.
Appreciate it. Okay, so here's the court's ruling. I'm going to walk through how you pretty much did your argument. First, the court is not needing to rule on the general jurisdiction issue because it's been stated that that issue is not being presented by counsels for plaintiffs. So the court's going specifically to specific jurisdiction. You all agree on the standard of specific jurisdiction. A court may exercise specific jurisdiction over a non-resident defendant only if one, it purposely availed itself of the privilege of acting in the forum state or purposely directed, bracket, its conduct to the forum state. Two, the claims are out of or relate to the defendant's contact with the forum. And three, exercise of jurisdiction would not, quote, offend the traditional notions of fair play and substantial justice. whether I go to defendant's brief where they've cited In re Paul Blumgar, the Nevada Advanced on 138, Nevada Advanced Op 79, 521 P3D 1160, or I go to Tricarchi, cited in plaintiffs, the same standards there, because Tricarchi is pretty much the same. It phrases it a little bit different. Tricarchi says, quote, specific jurisdiction is proper only when the cause of action arises from the defendant contacts with the forum, end quote, citing to Fulbright, internal quotations omitted. In evaluating specific personal jurisdictions, courts consider two factors. One, whether the defendant purposely availed itself of the privilege of acting in the forum state or purposely directed its conduct to the forum state, and two, whether the cause of action arose from the defendant's purposeful conduct or activities within connection to the forum state, such as reasonable to exercise personal jurisdiction, cites to Dagra, etc. But realistically, it's the same test. So here the court does find that specific jurisdiction does exist over defendants. For ease, I am going to adopt the specific analysis that has been set forth in the opposition. You have, well, contacts with the forum. You have all the issues with regards to related in the 89-page complaint has stated those are based on the context with this forum. It's the conduct and the context to the actual the actual users here in the state and the design aspects, whether you go to the data collection, whether you go to the coins, whether you go to the user agreements, whether you go to the advertising, whether you go to all the other contexts that are listed in the opposition, the court finds that prong is met. The court also finds that the second prong arise out of relate to the context with the forum. Yes, because that's where the claims are based on. See the 89-page complaint. And see the analysis in the opposition. 3, the exercise of jurisdiction would not offend traditional notions, fair play, and substantial justice. Well, here, court doesn't find that it would do that because in TikTok, knowingly, when it does all the things that it's asserted to do in the case, and remember, we're on a motion to dismiss stage, that's all the court has right now, is that it would be appropriate to find that it, quote, would be brought into the jurisdiction. So the court, without going through all the other cases that are cited in the pleadings, you all have cited earlier the standards, and so the court's adopting those cases with regards to standard and find it does apply here. Next, we go to the 230. So since jurisdiction, now I go to the 230 motion to dismiss based on 230. The court's going to deny that because really here, Lemon is instructive. Okay, Lemon is instructive because basically, while it's not mandatory, it is persuasive. And I'm going to go quote from Lemon. Each of Snap's novel attempts to expand CDA immunity beyond these straightforward principles is to no avail. To start, while providing content neutral tools does not render an internet company, quote, a creator or developer, end quote, of the downstream content that its that its users produce with those tools. Our case law has never suggested that internet companies enjoy absolute immunity from all claims related to their content neutral tools. It says, see, dry off, Kimsey, roommates, etc. citations I'm omitting. To the contrary, the CDA was not meant to create a lawless no man's land on the internet, citing roommates. Those who use the internet thus continue to face the prospect of liability if they're, quote, neutral tools, end quote, as long as plaintiff's claims do not blame them for the content that the third parties generate with those tools. When I look at that case and look at the other cases cited, on the totality of the different pleadings, the court really finds that this does not fall within the protections of 230. So therefore, on a motion to dismiss standard, I need to deny the motion to dismiss on that basis. Then we get to the First Amendment. With regards to the First Amendment, the court really does see this commercial speech, so it would have an intermediate scrutiny analysis. On the intermediate scrutiny analysis, obviously I'm taking into account Moody, because it is what it is. When I look at the nature, and I'm looking at a motion to dismiss, I do not see that the complaint as pled, and plaintiffs are the master of the complaint, is a preclusion under a First Amendment analysis. Once again, this is a motion to dismiss standard. So I have to look at what they said, not one party's interpretation of what they did. So then we get to the substance of actually the causes of action. Let's go to the causes of action. The causes of action set forth in the complaint. So we go to the causes of action, and your first cause, do I need to slow down a little bit? Sorry. I'm trying to be conscious of everyone's time here. I will speak a little slower, so anybody transcribing, I have a better opportunity. Okay, so let's go to the actual causes of action. So if you go to the causes of action, give me a quick second because I'm scrolling through the complaint. Get to the page where the cause of action starts. Okay, first cause. challenge with such long of a complaint takes a moment to be scrolled. I know you all gave me a jump drive, it's just as. That still takes me to scroll through, so it takes a moment, folks, no worries. Causes of action, count one, deceptive trade practices, 598.0903 through 598.099. That one, there was not an issue of the standing aspect because the plain language of 598 allows the Attorney General, so the court now needs to go to the actual merit-based analysis with the 598 claim. Here, when you look at, have to look at whether or not, quote, the design features, whether or not there is, quote, a product, or is it the nature of, quote, the consideration? Here, the court is, when I look at how it's pled and its parents' capacity to do so, the court does not see that the state's claims are treating defendants as publishers of the third-party conduct. Court really has to take the complaint as drafted, and then it's focusing on design elements, and so therefore that would pass muster under a motion to dismiss. So the first cause of action would be denied under a motion to dismiss standards. Yes, the court was also taking into account pool, which is cited in the complaint, as well as the other case law cited really by both parties in their motion. I have to look at whether or not under just straight deceptive trade practices with regards to the aspect. So then the court really has to look at whether or not was this a sale in the statute, right? It was a sale or consideration. Realistically, I think the case law interpreting that case, and I would have to go to some more recent cases, not of course addressing any cases that are still currently pending before this court, is that has been more broadly read, that it doesn't actually have to be a monetized sale. And here, because of the allegations of the complaint, to address the concept, I mean, enough that this court would have to view that there is, quote, consideration. And not just taking the user agreements, also taking the coins, which is a monetization is what I meant to say, monetization aspect. And I take, once again, in a motion to dismiss stage, I think it meets those standards, whether it's the data, whether it's the design features, whether or not it is the coins, I think it meets that. And the court's analysis is going to be similar. Well, it's pretty much similar under count two. So I need to deny a motion to dismiss with regards to that. And that was not a standing issue under the plain aspect of the motion to dismiss. Now let's get to count three, product liability design defect. Here, the court's going to grant the motion to dismiss, but give leave to amend realistically. And I appreciate the reference to a other case, which I can't say too much about because it is still technically currently pending before this court because there's bankruptcy and other matters. So all matters have not been fully resolved in that case. But there is a distinction because, well, I appreciate that as a heads up. Remember, in opioid, there actually was a product, right? There was the pills and medication too. The state of Nevada was asserting, and this is nothing for any merits-based analysis. I'm just kind of giving a simple distinction here because you all brought it up. There, the state of Nevada was stating it actually incurred expenses for all the underinsured and uninsured individuals. So you had something that was distinct, and so it was a bit different. So I did analyze that to see if there was something that was similar, try and be consistent in my rulings. Okay. But that being said, the design defect concept, I see the concept, but whether or not I've got issues here on the standing question, and I think that can be flushed out with an opportunity for leave to amend to see if it's something more than what is just currently stated. And second, about whether or not it is actually a product. Okay, so that's why the court finds it appropriate to grant the motion to dismiss, but give leave to amend. So I'm giving leave to amend, i.e. I am granting, you can treat it two ways. A, the court's inherent powers leave to amend, but here I've also got a counter motion for leave to amend. So I'm granting the counter motion portion as appropriate with the count three on product liability. And also the court would have exercised its inherent power anyway, because it'd be appropriate. Okay. So next, go to count four, product liability, failure to warn. Same analysis, although I appreciate the failure to warn is a little bit different, but once again, you have to have a clarity on what's actually the product. You have to have a clarity on the standing aspect. And so therefore the count four also is going to be dismissed with leave to amend i.e. granting the counter motion for leave to amend, as well as inherent power to grant leave to amend. Count 5, negligence, similarly here, standing issue. With regards to here, whether or not, since the negligence is who the duty is to, I don't think it's clearly articulated who the duty would be to the state of Nevada, and I think that is possible for leave to amend with the Nevada Supreme Court's preference, right, for trying cases on the merits and giving people an opportunity to have leave to amend. So I think there's issue of the duty. And so the duty ties into the standing analysis because the duty to whom, right? So that goes to the standing analysis. So it's the standing analysis and then the duty would tie into that. So court's gonna grant motion to dismiss, but give leave to amend with the 5th cause of action for negligence. And similarly, when you get to count 6, unjust enrichment, that's an equitable claim. Court would find it's appropriate to grant the motion to dismiss because how the state of Nevada would have the right to bring an equitable claim on behalf of whom, I think there's a standing issue there that, give an opportunity for leave to amend, right? But then because of its equitable nature, how the state of Nevada can step in the shoes for an equitable relief. I'm not really going the alternative to a contract issue because you could plead things in the alternative, but here really it's the issue of what is the state of Nevada articulating is unjust that it has the right to assert on behalf of whom, under what aspect. I appreciate, gives me a general statement in paragraph 355, but I think that needs to be clarified in Nevada law, how that would apply to this particular claim. So the court's ruling is motion dismissed, granted in part, denied in part with leave to amend in the parts that it was granted. With regards to leave to amend, I think as sophisticated litigators, knowing the extent and breadth and knowing that you might be trying to get a transcript, etc., I'm going to leave it to you all to give the court a letter or a stipulation, either a joint letter or a stipulation within the next 10 days on what you want to put in for the leave to amend date. Okay, because I appreciate you might be asking me for more than the 14 days under EDCR 7.21 to get the order in rather than going those back and forth. I assume as sophisticated litigators, you all can pick some dates that are going to meet your needs, provided the court in a proposed stipulation, and also put in that proposed stipulation the leave to amend date. Is that a correct assumption, or do I need to start getting at my calendar out now?
I think it's a correct assumption on behalf of defendants, Your Honor.
Yes, I think that would work fine.
So I'm going to tell you within the 14 days, get me the stip that tells me when you want to have the order done, right? A reasonable date for the order and a reasonable date for when the leave to amend would be triggered. Okay, so the court believes that it has addressed each and every argument and feels it has addressed its analysis. To the extent I've only gone over some of the highlighted ones, I am adopting the arguments in the case law in the pleadings. Does anyone request that this court go through your hundreds of pages of pleadings in your appendices and detail each and every element? I wouldn't want someone to think for purposes of any other future process that you might be doing that the court is omitting something. I'm not. I'm realistically trying to give you some of the general guidelines, but I'm adopting. The case law says what the case law says, whether I repeat it or not.
Understood, Your Honor. On behalf of defendants, no, we're not asking you to go through everything.
Counsel for plaintiffs, are you? If you are, let me know now.
I don't know, if with the court's approval, we would draft the first draft and provide it to counsel for review of the order.
Whoever wants to do it is gonna be fine with the court.
I think it's
Somehow
gonna be
I
a
think I'm-
collaborative process if they want to take the first shot, Your Honor,
Okay,
knock
so
themselves
we'll
out.
do that, and then you all can reach your agreements with regards there too. Is there anything from today's purposes that I need to say anything else or address anything else?
Not from plaintiff's side, Your Honor.
No, Your Honor.
Okay, then thank you so very much for the excellent briefing, for the excellent oral argument time today, and my team is, I'm gonna have to spend a few moments, I have to at least address this issue, sorry, team, before we head to lunch. Okay, I fully appreciate my wonderful team each and every day because they are absolutely fantastic and they go above and beyond.